Ready, start, para. In pursuance of that, assurance meetings were held with the representatives of the Central Workers Organization in July August 1995 in the light of the discussions held with different persons concerned. We have now brought forward another bill which is much simpler than the previous one and embodies for the employees concerned a machinery which would be largely internal to each organization. The bill which is now before the House is in pursuance of government's desire to provide for a proper procedure and machinery for the redressal of individual and collective grievances. The arrangements proposed are more conducive and less cumbersome than the procedure incorporated in the Industrial Disputes Act 1947. This bill provides for two types of machinery, one for the redressal of individual grievances and the other for collective grievances. Individual grievances will be looked into by the grievance redressal authority against whose orders and appeal will lie to the appellate authority. If any aggrieved party is not satisfied with the decision of the grievance redressal authority or the appellate authority, it is free to approach an independent tribunal whose decisions would be binding. All these authorities would be required to pass an order within a specified time. As regards collective grievances, this would be looked into by a management council, a bipartite machinery compressing the representatives of the employers and the employees, where a management council fails to settle any collective grievance within a specified period. There is a provision for reference of the grievance to an agreed arbitrator following which the grievance could be referred to a board of arbitrators headed by a judicial officer appointed by the appropriate government. In order to give relief to the smaller establishment, we do not propose to apply the proposed legislation to establishments employing less than 10 persons. We also propose to exclude from its purview establishments owned or controlled by government. This provisions has been made owing to the fact that government employees can take recourse to administrative or similar tribunals in individual matters and JCM or JCM type machinery in collective matters. We also propose to exclude societies registered under the Societies Registrations Act 1860, subject to certain conditions. One of these being that if they are entirely financed by the government, they would be excluded. Besides, educational institutions will cease to be covered in due course as and when the appropriate government makes a law for the redressal of grievances of employees. The government will have the power to exempt any establishment from its purview. Full stop. Over.